Hi, folks. Denise Howell here. And next up on This Week in Law, my co-host Sarah Pearson is here, along with Cristelia Garcia and Mike Schneider. We're going to talk about Neil Young. He's given up on streaming music. Have you? Things have gotten worse for Pharrell Williams and Robin Thicke in the Blurred Lines case. And you may want to call in some adult supervision. We're going to talk about 3D printed guns and marijuana use in Washington and Colorado. All next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell and Sarah Pearson. Episode 311, recorded July 24th, 2015. Risky Business. This episode of This Week in Law is brought to you by Harry's. For guys who want a great shave experience for a fraction of what you're paying now, go to harrys.com. Get $5 off your first purchase by entering the code TWiL when you check out. Hi, folks. Denise Howell here, and we are bringing you This Week in Law. We're really excited to be here. There's been lots going on at the intersection of law and technology, as there generally is. And we've got a wonderful panel of folks to help try and understand it all. Michael Schneider is joining us. Michael is a startup lawyer and the founder of Hivebrain Software. He's the co-host of the Law of Startups podcast, and he practices with Bitwise Legal. Hello, Mike.
Hi, great to be here.
Great to have you. Also joining us is Cristelia Garcia. She's a professor at the University of Colorado Boulder School of Law, where she teaches trademark, copyright, and property. In her former non-professorial life, she was a music and entertainment lawyer in Southern California. Hello, Cristelia.
Hi, thanks for having me.
Wonderful to have you. And also back on the show this week is my co-host, Sarah Pearson. Hello, Sarah.
Hey, Denise. Hi, everyone. Glad to be here.
Sarah is senior counsel with Creative Commons and has been very busy on an important project for Creative Commons that we'll talk about later in the show when we get around to it. First off, I think we will start out with some Hollywood and music and entertainment related stories because there's been a lot going on in that arena. So let's go there first. All right, always fun to talk some Hollywood and entertainment stories, and particularly music. There's definitely been a lot of movement and disruption in the music arena lately. There have been some lawsuits going on that we have some updates on, things that we've talked about before on the show. But really, the streaming world is in flux right now, particularly, I think, with the advent of Apple Music a few weeks back, and how that is affecting other streaming services and how artists have been reacting and singers and songwriters reacting to the royalties that they receive from streaming services, and coming to terms with the fact that streaming is here to stay, and how people have been consuming music and how people have been consuming music legally. So one thing that happened this week that was fairly interesting, I don't know if it means much, but it is a statement, and that is Neil Young posting to his Facebook page that streaming has ended for him. He posted a brief post saying that, and you might think that he was hitting on the Taylor Swift theme a la Apple Music, that, we artists and creative types are not making enough money from streaming services, but that's not what his complaint was. If you've been following along with Neil Young and his take on digital music, you might already have guessed that his beef with streaming music is the sound quality. He thinks that it's pretty awful in whatever format that you are getting your streaming music, and he just thinks it's a terrible experience for his audience. And he says he does not plan to distribute music in that way anymore. But I'm wondering, Cristelia, if you think that might just be him blowing off steam, and can he really speak for those who are in charge of distributing his music?
Well, so whether he can speak for those who distribute his music is very contract dependent. I'm not sure what his record deals look like, what his publication deals look like, but I do think there's a couple of interesting things going on here. Many of the listeners may have listened to Neil's announcement at the South by Southwest conference last year. He is the primary investor in a venture called Pono, that's Pono, and it's this newfangled kind of triangular shaped music playing device, like an alternative to the iPod that its whole pitch is that it streams higher quality audio. So the idea being that you would have bought his album apparently and compressed it using a high quality file, and then you play it through the Pono and it sounds better than, say, playing it through the Apple earbuds that you are currently wearing. And so, there may be a little bit of self-interest in his comments here because he's trying to stress audio quality so people will buy the Pono. But the other interesting thing that's going on here, and we're seeing this as some of the new streaming services are trying to differentiate themselves and get an audience. TWiL is the big sort of Jay-Z joint venture that was announced in a press conference back in March. The idea that they're trying to sell this higher quality auto as somehow a better option than what you might get through a lower quality auto, presumably we're supposed to think that's Spotify. I fancy myself an audiophile, but the reality is that most people can't tell the difference. There are a couple of NPR had some interesting stuff recently where you could listen to a bunch of files in different qualities and see if you understood the difference. The reason we often can't hear the difference, and maybe what Neil Young misses here, is that most music listeners don't have the equipment to hear the difference in the files. If you're listening to the music in your car or through your smartphone, which are the two most popular ways for people to listen to music, it's basically impossible to hear the difference between the files. And if you're listening on Neil Young's Pono device, you may hear a difference if you've trained your ear. But it imagines that all of his fans have very expensive audio equipment in their homes and that that's where they're listening to the music. I don't know how, genuine or disingenuous these sorts of comments are, but I don't think that audio quality is what most people streaming music are concerned about.
Right, and it seems a little strange to me that Neil Young, he may have preferences for, like a movie director might have a preference for how his work is consumed, but to go ahead and take it upon themselves to dictate what sort of equipment people are going to buy seems to be a bit reaching and a bit naive. And it does seem like, Cristelia, that, you mentioned cars and smartphones, maybe Bluetooth speakers. I'm hard pressed to think of, a whole lot of rank and file lay people going out and investing the way people did when I was young and growing up in high quality speakers that they're installing in their homes. If anything, maybe artists who are concerned about sound quality should be focusing not on the delivery channel, but on the speakers themselves, that pick up the streaming or however else you're getting your compressed music delivered. It seems like if speakers could do a better job with the compression, then maybe these issues would not be of such a concern. When I was reading Neil Young's post, I had my little Amazon Echo device in the other room that happened to be on a Prime playlist that was streaming Neil Young music at the time. So the irony there was pretty rich. And I'm one of those people that, I'm happy to just have it playing in the background and not terribly concerned about having booming bass, et cetera, and all the various textures of the audio channels that you can get listening on something other than an Echo device. Sarah, what's your take on this?
Well, it's interesting because when I first read his Facebook post, I guess I kind of thought, oh, how that's kind of naive and sad in a way. But now here, I'm so glad that Cristelia had that other information because I didn't realize about his potential monetary or financial interest in this. And so that kind of makes more sense. It sounds like maybe there's more to it than just, I don't want my stuff played on low quality. And it's, there's actually an economic motivation here that, I don't know, that kind of solves a little bit of the mystery for me. Because I just thought, Yeah, I mean, it seems crazy to say. It's one thing to say that you encourage people to listen to it using higher quality audio files, but it's another to just completely pull out from the market. I'm also one of those people, I think I've mentioned before on the show, that I'm one of those people who cannot tell the difference at all, and I'm not a music person. So to me, I just don't understand the motivation at all to take yourself out of the streaming market. But
well, let's play this out for what it means to the music business. Neil Young may be a voice in the wilderness on this audio quality issue, and I am willing to give him more than the benefit of the doubt that the Pono device is not, it's obviously something, it's a financial endeavor, but I think that it's also a labor of love, and we should all go back and re-listen to his appearance on Triangulation on the TWiL network and see what we think about his motivations for making the Pono. And I do think that, it's something he created to address the issue that I mentioned earlier, that, that our listening devices are not capable of delivering sound quality that is up to very high standards, and he wants to solve that problem in his own way. But suppose he's not just a lone voice in the wilderness, and he gains some support with other artists, and they decide that for financial reasons, perhaps as well, streaming is just not their distribution channel of choice. Crystalia, do you think that will have an impact? Can there really be a going back at this point?
I don't think so. I think there have been some artists who have resisted streaming in various ways, right? You'll recall, Prince a couple of years back saying that the internet was dead, so he wasn't going to be putting his music there anymore. Luckily for us, he was wrong. Taylor Swift said she wasn't going to share her music with Spotify. This was a pricing issue. She will give it to Apple. We don't understand that the pricing is that different. Maybe it is for her, right? There will be some artists, perhaps the Taylor Swifts and Neil Youngs of the world, who can remove their music from streaming and get fans in other ways. But that's not going to represent the vast majority of artists. And it's also not going to represent something that will work for the vast majority of fans, right? Who are just looking to hear some music on their way to work or on a run, or just want to hear some song that their friend told them was good. And I think that's going to continue to come from streaming. From a logistical point of view as well, artists who are newly signing on to record deals will most likely have streaming built in. Again, there will be some artists who will reach a Taylor Swift point or a Neil Young point who may have some sway over what's done with the distribution of their music. But a lot of these record labels are in joint ventures with companies like Spotify. And if you sign a deal with them, your music's going to be streamed. I would think that it's unlikely that even a handful of very powerful musicians pulling out are really going to make an impact.
Right. And as far as streaming goes, I mean, it's been this, although it may be an ill to certain creatives and artists who are either not wild about the sound quality or the financial arrangements, and we're going to get into some of those in a minute here. But it has solved a number of other problems, including it has made digital distribution of music actually a money-making proposition for the industry, as opposed to just having songs ripped and shared, as was very prevalent before. And Mike, I'm wondering, as you've been listening to the discussion, whether you think that there is a startup opportunity here that could possibly address some of the concerns we've been going over.
Yeah, I mean, streaming in general isn't going away. You've got high-end acts like Neil Young who have the luxury of pulling their stuff off of streaming. Apparently, I believe him when he says that it's not about the money, because by walking away from a huge percentage of the market and saying, I only want to sell my music to people that want to buy expensive equipment, I mean, he's really walking away from a huge, financial gain that he would have from selling his music. So he clearly cares about high-quality audio, and so there's going to be some artists that feel that way and aren't on streaming. I don't know if there's a way to sort of make that music available to people that are consuming their music exclusively through streaming sites. So maybe there's a startup opportunity there. I think in reality, it's going to be big enough acts that they feel like they can sell their music as MP3s or on a disc, trying to go it alone. And anybody else that's actually trying to build a name for themselves or build an audience base, they're going to have to be where the listeners are. And streaming is an amazing opportunity for musicians. I think some of the materials we looked at before the podcast showed some of the revenue numbers for the music industry over the last several years are going up for the first time in a while, I think. And that's all because you look at a typical user on a streaming site, and I use myself as an example. For years, I maybe bought a couple albums a year. But now I subscribe to Rhapsody, and I also subscribe to Apple Music. The amount of money I'm spending every year on music is probably sevenfold what I used to spend. And if you do that across the board for people that, the vast majority of people who probably don't buy a lot of albums, you're looking at an overall increase in spending on music. Plus, from a legal standpoint, you'd think artists would be all over this because it's also a reduction in rights. You get it's just like the ebooks versus physical books. When you sign up for a streaming service, you don't own a copy of the music that you can sell to someone else or keep forever. When you stop paying, you lose access. So you're basically signing up to pay monthly for as long as you want to listen to the music, which if that money is being passed through to the artist is a great deal for them. And maybe one thing you might look at is, because there's more money being spent, but streaming enables people to listen to a wider variety of music that they might not have otherwise bought. The money is being split up over probably a wider variety of artists. So whereas the money that I was spending on music in the past was going to a couple artists that I bought CDs from, now the money's being split up over hundreds of artists that I'm trying out. And maybe I don't listen to the albums as many times. I mean, that could hurt people like Neil Young, because Neil Young is the kind of artist that people will buy albums from. And so if some of the money is going to smaller acts and spread out further into the long tail of artists, that might hurt people like him and Taylor Swift. But overall, it seems like it's a real positive for the industry, and that they should probably get on board to help the tide raise all ships, as you will.
Right. Hey, Crystalia, I'm curious to know whether you think that we're going to see a shift in the industry. We know that artists are not happy about the revenues that they're receiving via streaming. Bob Lefsetz, in writing about this move on Neil Young's part, posits that if you are an up-and-coming artist, the way to deal with that problem is to not sign with a major label, to just say, we don't need your marketing and whatever else you offer. We're going to go direct through whatever streaming services we opt to distribute through, and we're going to get a bigger cut that way. Do you see a shift in that direction?
Well, it's certainly true that it's easier now than ever before for new artists to, first of all, record their own music, right? You used to need a record deal to even get into the studio. Studio time was expensive and the equipment was expensive. With technology and software today, you could conceivably, and many people do, record albums themselves at home, right? So the actual creation of the album is much cheaper. And the distribution is virtually free, right? You've got all the streaming services that you can. There are a variety of, very affordable companies that you can send your files through, and they'll put them across a broad spectrum of distribution channels. YouTube, for example. I think it's a bit misleading to say, and therefore you don't need a record label. You don't need the marketing, right? Part of the problem with this ease of the creation and distribution of music is that it increases the quantity of music. And, putting subjective issues of quality aside, when you've got a lot of quantity, there's got to be someone who's breaking through all the noise and telling, me and other fellow music listeners, listen to this, right? That's really much more the role that record labels are playing these days than they used to. That they're not, wrapping, jewel boxing CDs and shipping them to Target. And, they are, but that's not their big function. They're really cutting through the noise and saying, listen to this person and that person and that person, and it's not just record labels, music blogs are doing that for people who prefer different genres of music. So you can find different places to access your music. But marketing is something that's difficult to do on one's own. I think that's really the function where these play. Bob Bluff said he's assuming a band maybe that already has a fan base. But I think that's pretty tricky to get to without any sort of marketing. Although, as I was saying this, I was thinking too, if we think about the most popular ways for people to listen to music, I had mentioned your smartphone and your Spotify sort of streaming services. But even in terms of if you look at the charts that show like what services people are using, YouTube being this free source is the most popular, where people are generally listening through like the little crap speakers on their laptops. So, in terms of the most successful venues for people to listen to music through, the audio quality is definitely suffering. So that may be a cut against how concerned consumers are with audio quality as well.
Right. We're all being trained to not expect too much.
For better, for worse, right?
Yeah. Let's talk about this Berkeley Institute report on transparency and fairness in the music industry. Crystelia, what did you learn from that?
This is the new Berkeley report?
Yes.
I think one of the big takeaway points for folks who weren't aware of this is not so much that, music royalties and licensing are complicated and messy, which I think most people have kind of grasped, at least tangentially, like this is a mess. Although it does a really good job of highlighting why it's so messy, that, music, unlike a lot of other content, has two different copyrights, right? There's a copyright on the underlying musical composition, used to be called the sheet music, but now it can be a variety of things, and sound recordings of that musical composition. So part of it is we have these two different copyrights, and royalties and payments are collected not only on separate copyrights, but by separate companies. Often a performer who also writes their own songs, will have both a publishing deal and a recording deal, right? So it kind of highlights the mess. But I think maybe the most important takeaway for those who aren't as close to this industry is how very little of the monies actually get back to the artists. And this is an ongoing sort of problem and debate in the industry. A lot of it's contractual, right? And so we could say, well, if the artists want to get a bigger cut of, say, streaming deals, then, they should negotiate for that. But as with a lot of these entertainment fields, and it's no different in film studios for actors and in book deals for new authors, the bargaining power disparity is a little lower when people are still, just coming in. And so oftentimes they're signing the deal that they can get so that they can get their material out there. And by the time these very, very small royalties, already as they are for streaming, are trickling their way through the system, what actually ends up coming down to the artist is I think the report shows somewhere around 40 to 50% of the royalties are actually making their way to the artist. So I think that some people have found that to be somewhat of a surprising takeaway from the report.
40 to 50% of the royalties are making their way to the artist?
Right.
But it's just that the amount of the royalties themselves are smaller than they used to be. Is that the main complaint?
Right. I think it also wasn't as obvious before this was all being done digitally, right? Now that it's being done digitally, it's easier to, first of all, to sort of parse out that 40 to 50%. So it's like, oh, well, maybe it's always been 40 to 50% of whatever the royalties were, but we didn't see the number. It's also, of course, the fact that number that we're taking 40, 50% of is now so much smaller, right? So 40 to 50% of CD sales when CDs were selling for $16.99 each is quite different than 40 to 50% of, a billion streams at 0.00025 cents per stream. Do you know what I'm saying? So I think
yes.
Both the ability to pull a percentage and that percentage being of a much smaller number is what's really started to highlight this for folks.
I'm curious, when you were in private practice, did you ever have artists that you were representing who tried to strike better deals for themselves and had any success at it? So
I worked for first for MySpace Music when we were doing streaming deals with the labels. So I wasn't representing artists in that capacity. Then I worked for Universal Music. We did have a case that many of you guys have probably heard about. We weren't on the winning side of that case, but I think that the result made sense, and that was the Eminem case. The Eminem brought a suit when streaming was first taking off to challenge terms in the contract that didn't exactly, at the time that he entered his contracts, right? Streaming music wasn't a thing. There were vague terms about, distribution by CD, distribution on the radio, and then sort of other distribution. And what he did was wanted to go back and renegotiate what his percentages would look like off of streaming music once it became evident what a large proportion of the revenues streaming was going to take up. And that was, growing pains, if you will, or a learning lesson for both the labels and for the artists. Contracts signed prior to that time just didn't contemplate that source of revenue because it didn't exist. Even if they began to contemplate sort of, digital, they didn't realize that streaming was going to become the big thing. When they were talking digital, they were talking digital downloads or the MP3s that you can buy through, say, iTunes or Amazon MP3. So there's a lot of, the most common adjustment for artists to come back is to try and accommodate new technologies.
Right. And I think that new technologies sometimes come out of left field and enable ways for artists to make money that they might never have thought of, and that we continue, as we continue to see the industry evolve, there might be, something entirely unexpected. Maybe it is, and already we see differences in pricing on iTunes if you're actually going to download between various compression qualities. You can get, whether you're having DRM or not, maybe those are ways to differentiate. Recently, you were saying, Mike, that you are spending more on music now than you have been in the past. I'm not sure if I could say the same thing. I think I built up a pretty substantial downloaded iTunes library at $1.29 a song for a while there. And then once I moved more into streaming, that somewhat halted. But, like out of left field, sometimes something comes along that makes you spend money again on music. And for me, it was Lisa Bettany's V app, which is a video editing app that runs on your phone and also ties in with iTunes. So if you want to add music to your videos that you've created, then you either are using the downloaded music you've already purchased or you're buying something new. And so I've been buying iTunes music again for the first time in years, literally, to put on some videos that I've made. Now, I'm sure that is a completely niche little example that isn't going to line a whole lot of artists' pockets. But I think it is an example of the way that, unexpectedly, all of a sudden, I find myself buying iTunes music again, where I didn't think I'd ever need to or want to. Sarah, anything you want to add to the discussion before we move on to some of our other entertainment topics?
The only thing I was thinking is, as Crescelia was talking, I think she was making a great point about how there's still a place for labels in the sense of help with marketing, because there's so much more music out there to consume, and how do you get noticed? But then it's interesting to then contrast with that how much what a big percentage at this point they're taking. So you kind of have to weigh, does the boost in potential marketing from the label kind of outweigh the huge cut that they're going to take? And I imagine that it's going to start to be that cut will be smaller and smaller as people figure out different ways to get noticed without them. But it'll be interesting to see how it all plays out. Lots of disruption going on for sure.
Okay, so we've talked before on the show about the blurred lines case, and we heard from the judge in that case. This is something that happens pretty frequently for folks who don't really follow lawsuits. This is not an uncommon thing to have happen, is for a jury verdict to come down. And in this case, there was a $7.4 million award in favor of the Marvin Gaye family against Robin Thicke and Pharrell Williams over the Blurred Lines song, which the jury agreed resembled a Marvin Gaye song, got to give it up. in an infringement-worthy way, as they put it in Rolling Stone. So there was this $7.4 million award that got cut down to $5.3 million by the judge. The judge can come in and say, well, I think the jury got some things wrong in certain ways, and I'm going to make some adjustments before I'm ready to say this case is over at the trial court level. Of course, there can be appeals, and I think in this case probably certainly will be from there. But by reducing the verdict, I actually think, and Christelia, tell me if you agree, in reading through the coverage here, that things actually, even though the verdict was reduced, things got worse here for the defendants, Robin Thicke and Pharrell Williams, and also for another party called T.I., a rapper who originally was not part of the decision, and the judge decided, nope, you're a co-songwriter and should also be on the hook here. So things actually kind of got worse when this verdict was reduced. Can you explain to us how?
Sure, Denise. I agree. I think that sometimes you've got to be, careful what you wish for when they pushed back and wanted a reduction in the verdict. They certainly did knock a couple of million off, but what happened there was it went from, just rounding the numbers, from $7 million to $5 million, but then the judge added 50% of all royalties going forward. So in other words, he reduced the verdict by $2 million, which is great, but opened up the door for a much bigger upside going forward. I think what the judge was trying to emphasize here was, if the determination is that this was unlawful borrowing of musical elements, and that's highly debatable, right? Some people think this is the worst decision ever. Some people think this is a great decision, and that includes people on both sides of sort of the ideological spectrum in terms of, sort of artists' rights and copyrightists and copyleftists, and it's certainly not a perfectly neat decision. I think you guys have maybe already talked about this, but what it does do here is, it gives a very, what I would call a very minor reprieve of a mere $2 million on a song like this, and opens up half the royalties going forward are going to need to be shared with the estate. If anything, I think that this is probably a much stronger statement by the judge on how important a role Marvin Gaye's music and influence played in the construction of the Blurred Lines song, and represents a much more a much larger role that it played, representing a much larger cut of money going forward. It's true that the song is now not what it once was, so he didn't give 50% of all royalties, retroactively, just going forward. So maybe the upside won't be as big as it would have been if that had been the verdict from the beginning. But I think that, the song still has some legs, and licensing going forward, I think we'll see they'll still enjoy a bigger upside with this. That would be my guess.
In the wake of this decision and decisions like it, how do you think artists are supposed to think about in advance their inspirations for the music that they've created? This seems like it would have been a tough catch. That putting Pharrell Williams and Robin Thicke here in the role of George Harrison, going back to the My Sweet Lord case, and He's So Fine. How are artists supposed to determine, gee, there's another song that this really sounds a lot like, if they're not intentionally trying to adopt and mash up that song, which I don't think is what was going on here.
Yeah, that's a good question, and I think that's one of the strongest criticisms of this case. Not least of all from artists who feel like there's nothing new under the sun, right? I think it was Bob Dylan who said, he steals everything. There's only so many chords, there's only so many notes. You can only put them in so many ways to come up with guitar riffs. But beyond that, and some of the troubling language in the Blurred Lines decision, it even goes on to, and I think Pharrell was rather open with this in his deposition testimony, just inspired by certain genres, right? So if he wanted like a funky song, right? So you might argue, well, all of the songs in the genre of funk have a funky sound. Anything that sounds jazzy is jazz. And so at what point do you have to draw the line and say, well, of course the artist was influenced by artists that came before them, but this is not, we'll know a remix or a mashup when we see it. That's the tricky part here. Some of the elements, the specific elements that were pointed out in Blurred Lines are hard to swallow, right? Because you can't just be inspired, but you have to pick out particular elements like, singing in a male falsetto. It seems, a bit of a stretch to give that to Marvin Gaye. Decision to use a cowbell. Decision not to use a guitar. Like, these were some of the things that they pointed out. I think we start to teeter into dangerous territory when we pull out elements like that. I'm all for recognizing the influences of great artists, but if we're going to have decisions like this, I would prefer to see Congress in its sort of revisions of the Copyright Act give us very clear outlines and guidelines as to what it is that is and is not going to constitute infringement, because otherwise I think, as you said, Denise, you leave artists in this really murky territory of not knowing what they can and can't use. And my concern as a music fan and consumer of music is that this could actually deter people from innovating and creating new music because they don't want to have a successful song and then be sued because it kind of sounds like something else within their genre. The sort of disincentives for creation would be my biggest concern.
Right. So, Mike, I think we're back to another startup opportunity, perhaps, because in other areas where intellectual property is at stake, you can go and do a bit of advanced research and try and do some compliance before you go ahead and, if you think you might be infringing on someone's trademark, you can do some research on that. If you in some senses, you can look for copyrighted works by seeing if they are registered. That doesn't really address the situation that we have at hand here, where a tune is your inspiration and you might not even realize it. Do you think, with all the music ID technology we have available now, maybe we need an app for artists that takes their song and tells them everything it closely resembles?
Yeah, you'd think that would be certainly something they could do. It's tough. Fair use is a really scary issue, not just for musicians, but for the software companies that I work with. People that I work with, a lot of game companies and software companies, and the problem is whenever you start looking at using something under the guise of fair use, you really don't know how the court is going to interpret it. You're always weighing factors. And so in this case, I agree. I don't know that I would have expected this kind of outcome. And the bottom line is, if you're using someone else's musical work as an inspiration, or in the case of software or the game world, using inspiration from another game, you're always running the risk that once you achieve a certain degree of success, that people are going to come out of the woodwork and try to challenge that assessment that you made. In this case, it went badly. But even if they hadn't lost, the case still exists, right? They still have to spend the money and fight to try to defend the choice that they made. So anytime you're building something based on something else and you're relying on fair use, you're always exposed to that vector of attack. So yeah, it is a little bit chilling on innovation. I guess the only counter to the chilling argument is this sort of stuff, especially in the music industry, seems to only really kick in at this level when you achieve a high degree of success. And it's almost like the question about whether taxes decrease like entrepreneurship, whether if you tax someone too much, it'll eventually stop people from wanting to innovate because they won't want to pay the tax. And in this case, I kind of wonder, like, the prospect of losing a percentage of what you make as a result of a case like this. I don't know if that would discourage someone from making a song, because I hear the same thing from startup companies where they say, well, let's go do this. We're going to take the risk from a fair use standpoint because we're young, we're bootstrapping, and this problem will only become a problem for us if we achieve like a high degree of success. And at that point, we've achieved some degree of success, which is that's not guaranteed. So let's go ahead and do it and see where we end up. Same thing here. Put the song out. There's a chance you could get sued. They got hit pretty hard in terms of a 50% cut of royalties. That's a pretty serious hit. But I still don't know that risk is a bad risk to take, because they're still keeping the other 50%. And when they made the song, there was a good chance that they wouldn't have to pay anything at all. Yeah.
I was thinking the exact same thing about the chilling effect, is that the vast majority of musicians out there aren't going to, this case isn't going to affect how they operate. I think the chilling effect it might have is on, in the very commercial music, they will try to avoid anything that sounds like other songs, and potentially, not being as honest about their influences, which I think is a really unfortunate consequence of this case. Because if I remember right, they talked openly about how they were trying to pay homage to Marvin Gaye's song, and that they had, copied a feeling, I think was what they had said. And so, and they got burned because of it. And so I imagine the PR that people have around their music might change a little bit for the when we're talking about highly successful commercial musicians. But in terms of kind of the way that, people develop music organically, like, around the world, I don't imagine it having a big chilling effect. Lots of people are just making music because they are inspired to. I think it'll affect a pretty narrow market.
It would be interesting if there was like something like a compulsory license that would allow people to take inspiration from other music and not worry about the royalties coming from that being too huge. I mean, you can cover a song right now, and there's compulsory licensing under the law that requires you to pay a fixed price for that license. I don't know if that would go against, when you're remixing something or using it as inspiration, you're kind of taking the thing that the artist did and turning it into something else, and maybe they'd want to have a say in whether they're okay with that, as opposed to a cover where you have to stay a little bit closer to the actual integrity of the original song. But it would be interesting if there was some kind of a way for people to be able to leverage pre-existing work in creative ways, and know that if it did get challenged, there would be some kind of a statutory fair royalty that they could rely on, so that they could start, repurposing more music and building on it.
That's an idea that's bounced around quite a bit. What were you going to add, Sarah?
No, that was Cristelia, I think.
Oh, sorry, Cristelia. Yeah, I was just going to ask you if this notion gets tossed out and sort of brainstormed quite frequently, but never has made its way into law. Do you see that changing?
Sure. Like you mentioned, there's been a number of proposals to expand the compulsory licensing in music. As Michael mentioned, we have a compulsory license for people who want to cover a song. All that means is that if you want to cover someone else's song, you don't need their permission to do it. In other words, they can't tell me I can't. I just pay the statutory rate and I can cover the song, as long as it keeps, it's not a full transformation of the work, right? That I'm keeping more or less to the composition. So there have been some proposals to expand this to include remixing, to include sampling, where you can create with more freedom, because you can remix or sample and you'll just pay what the cap on your damages will be, right? You'll pay just whatever the statutory rate is. Not all people like this, for the same reasons they don't like the existing compulsory license for covers, right? Which is to say, well, it takes some control away from the artist, and that's what copyright's supposed to do. It's supposed to give the artist control over what happens with the music that they create. And the debate has some good points on both sides. All of this comes down to incentives, right? So copyright was intended to incentivize creation. And you ask, well, if you... would Marvin Gaye have not created his song if he had known that sometime after his death, his grandchildren weren't going to get a cut of, songs that played off of his song? I think, as, Denise and Michael and Sarah have said, no, it probably did not play at all into the incentives of whether or not he would have created the song. Likewise, will people not create music if they know that someone can remix it? I don't know. Maybe Neil Young won't. It sounds like he may, be against all things newfangled. But for the most part, musicians are going to create the music, and they'll take the royalty if they can take it. And it won't necessarily make an impact. I just think that if we're going to go around talking about incentives of creation, it kind of goes, it goes on both sides of the spectrum. And I think that if we if we think that artists really care, as the Blurred Lines decision would tell us, about what's going to happen with their music in the future, then we should assume that setting up these compulsory licenses might be something that they care about too, because then they can get paid without having to go through expensive court battles. You know, there are lots of musicians who aren't Marvin Gaye who don't get their day in court to say, hey, I think you took my riff, right? Because it's really expensive to do so. And to the extent that copyright is supposed to incentivize those artists too, you know, maybe we're not doing such a good job of that.
Yeah, the artists also have to make a choice about sort of where they stand on it. Like, so Marvin Gaye had to decide, or his estate had to decide what, you know, we're going to take the position that building this off of our song is something that we should be owed money for. And a lot of artists don't agree with that approach. I would think, you know, most artists have built based on inspiration from other musicians. So, you know, you have to decide where you stand on it. And if there was some kind of compulsory system where people could take advantage of it without taking the position that, you know, quite as aggressive a position to say that stuff built on my work should be completely controlled. Because, you know, particularly if you're a musician who's taken influence from other people, you know, you have to wonder whether it's counter to that, to then take a position later once you're successful to go after people that are trying to build something that stands on your shoulders. But if there was something like a compulsory license or a better system for that, there might be a way for people to get paid a more reasonable amount without having to take a position that might be completely counter to, you know, their own philosophy about you know, building on other people's music.
Well, there's a lot more to talk about when we're talking about music that inspires other creative works versus the use of works totally identified and it's a conscious use without permission. And we're going to get into what can happen to someone who decides to follow the ask forgiveness, not permission model in a bad way in just a moment here. We're here with Cristelia Garcia and Mike Schneider and Sarah Pearson and me talking about some interesting new cases going on at the intersection of music and technology and law. And we're here doing this thanks to the wonderful sponsors on our network. And our sponsor for this episode of This Week in Law is Harry's. Harry's is fixing a problem that most of us have, paying way too much for overpriced razors. Let's admit it, shaving is not, you don't wake up in the morning thinking, I just cannot wait to get my shaving on today. It's not the funnest thing. It's not what gets you up and starts your day. It's something that we all need to take care of in one way or another. Sometimes we get cut or scraped by our razors that have dull blades or the cheap off-the-shelf blades that you might have picked up at the drugstore. And if you go for the expensive ones, they're really, really expensive. They run about $4 a blade. And someone who shaves every day winds up spending hundreds of dollars a year. Just think hundreds of dollars you could spend on your music consumption, for example. What they have, though, is high-quality razors at about half the price of those big brand blades. They make their razors in their own factory in Germany. They engineer them for sharpness and high performance. And Harry's ships them for free to your front doorstep. And because they make and ship their own blades, Harry's is a more efficient company, which means they can give us factory direct pricing and it guarantees your satisfaction. In each kit, you get a razor with a handle that looks and feels great, 3 razor blades, and foaming shave gel. And importantly, like I mentioned, when you're off traveling, you want to make sure that you have a good razor with you so you're not having to buy cheap blades and cut yourself. I don't know about the other women in the audience out there, but there have been times in the past where I've forgotten a razor at home and had to pick up, you know, just the pack of little disposable blades and run around for the rest of my vacation with all the little nicks up the front of my leg, because that's how they treat your legs. Not nicely, not like a Harry's blade. So importantly, also in your Harry's kit that arrives is a little cover that you put over your blade, and it makes it very simple to just throw it in your bag and take it with you when you're traveling. The starter Truman set is an amazing deal. You get all this for just $15. I've been using Harry's for a while now. I'm so glad that when I am on the road, I no longer need to worry about, oh, gee, I left my razor at home and now need to pick up a cheapy one, because I just always keep my Harry's, my extra Harry's razor in my travel kit. And It goes on the road with me and keeps my legs nice and nick-free with a close and comfortable shave. I love the look and feel of the set, and I love the price. Harry's costs half as much as the razors at the store. They also have a new aftershave moisturizer that protects and hydrates your skin. So you've got to check it out. Male or female, it's a great product. Go to harrys.com and get $5 off your first purchase with the code TWiL, TWiL. That's harrys.com and enter code TWiL at checkout. Thank you so much, Harrys, for your support of This Week in Law. So let's talk about what happens when you decide your Monster Energy, for example, and you decide, hey, a great marketing ploy for us would be to incorporate some Beastie Boys music. What Monster did was put together a bunch, like a medley of Beastie Boys songs as part of one of their marketing efforts. But whoops, they never got someone like Crystalia on board to take care of their licensing issues in advance. So the Beastie Boys were not happy about this at all. These were not songs that inspired Monster Energy to create another work. They were just songs used by Monster Energy to put together this medley of tunes. Which I guess, I don't know, maybe correct me, putting together a medley of tunes is in its own way another work. I don't know if that came up in this case or not. But what did come up in this case was the fact that there was no permission sought or granted, no licensing at all. So not only did Monster Energy lose, but now they've been told that they must also pay the Beastie Boys legal fees. Not all the legal fees that the Beastie Boys incurred. They had been seeking $2.4 million just in legal fees. The court decided that's a bit steep, and you didn't have to necessarily hire the Rolls Royce of legal representation and pay all that much money in fees. But they did get $668,000 to cover their legal fees against Monster Energy. Crystalia, any other thoughts on this case?
I thought that this was a particularly surprising case. It was a bit of amateur hour for a company like Monster. And I don't just mean Monster in that it's a big company with a sophisticated legal team, but it's one of the most litigious companies out there, at least on the trademark side, which means they have some in-house intellectual property folks. And they also, outsource quite a bit of this work. They sue anyone who, uses the color green and anything in threes, right? So it was really surprising that they would... take the sort of ask forgiveness, not permission approach. Also that they would do it with the Beastie Boys of all bands, right? The Beastie Boys have recently made it very clear that they don't do endorsements. It was an Adam's, will, and we saw the issue with the girl Legos. The Beastie Boys are just not tolerating it at all, and so it was surprising to me that they went with Beastie Boys and that this happened without permission. But, I guess they decided to just take a shot. It's pretty surprising because there was no sort of fair use argument around it.
Right. I mean, it seems like, there's maybe a bid for a fair use argument that could happen there. But given, the amount of each of the songs that was used and the fact that the use was over 23 minutes long, it seems like they would have had an uphill battle there. And I agree with you. Amateur hour is pretty dead on. If you're a big company and you're going to use something musically in your marketing, you better be thinking about licensing it. Any other thoughts, Sarah?
No, I mean, it just sounds like a no-brainer.
How about the reduction of legal fees from $2.4 million to $668,000? I bet there are people listening to our show who are just, their eyes are bugging out and their jaws are on the floor thinking, what? How could the legal fees alone in a case like this be $668,000 or, goodness forbid, $2.4 million? But that's not that unusual, is it?
No. I mean, I've been out of private practice forever now, so I think I forget. But yeah, it's really easy to rack up millions of dollars of legal fees, especially if you're working with a big law firm. I don't know. I imagine these were big law firms, so not surprised at all that it would be millions of dollars.
Yeah. Mike, any
the one
thoughts
thing
on
that
this?
occurred,
Oh, go ahead, Christelle.
Oh, I was going to say one thing that occurs to me now that I'm thinking that through the numbers, perhaps Monster knew, because Beastie Boys has been very open, we're not going to take endorsements at all. So there was no amount of money they could have offered the Beastie Boys to put together their promotional, mix. And so in the end, $684,000 or whatever it is in legal fees, for their marketing budget, maybe they felt like they got the Beastie Boys to promote their product kind of on the cheap, whereas if they'd asked for it, they never would have gotten it in the first place. So I'm not a marketer, but perhaps that was the strategy. I don't know.
Was there a judgment on top of the legal fees? I mean, it seems like for one thing, it seems like a bonehead move on Monster's part. I don't see how they could have spent any time at all thinking about this. Somebody must have just done it.
Right.
I mean, the idea that they would say, "Oh, let's put a bunch of Beastie Boys songs up, and we'll just distribute them." I mean, I don't know what analysis could have possibly been done. I mean, even if you're saying, that would be just so risky to say, we're going to put this stuff up and just wait for them to sue us because we know they sue everybody. So we'll just pay what the court decides we should pay for this music when they could just get a license from, another band that doesn't have the same objections. That seems, just has to be a huge mistake on their part. But what I don't understand is what did they fight about? Like, what was I guess we have, $2.4 million worth of battling. That's just one side. I mean, what were their arguments? It seems like a pretty open and shut case. I don't see the fair use piece because of the commercial aspect of it and the amount that was used. It seems like it's tough. And then I also kind of wonder if it makes sense I'm not a litigator, so I don't see this part of the way things work that often. But to say that the Beastie Boys shouldn't hire the best lawyers they can and spend however much money they think is reasonable to enforce their rights, it seems strange for the judge to say you hired too expensive lawyers. Like you should have hired someone worse or somebody that doesn't charge as much. That seems like, they obviously weren't. It was no guarantee that they'd get their attorney's fees paid, and they still felt that was the money that they wanted to spend on it. It's odd for them to kind of question that judgment in a case where it's so clear cut. And it sounds like I'm guessing Monster's the one that just didn't want to settle it and wanted to drag it out because, I don't know what good faith argument they could be making that it was okay for them to distribute someone else's music without a license.
Yeah, Christelle, do you know what they argued at trial?
I don't. I don't know what the possible explanation could be, unless something like Mike alluded to, where they were trying to claim that it didn't come from them, right? That maybe an employee put it up unauthorized or something to that effect. So maybe there was some argument around like whose responsibility it was, or negligence or something in getting the tape up. I'm not sure. I do think that part of I agree wholeheartedly with Michael that it seems odd to tell a plaintiff or a defendant, how much they can and can't spend or what quality of legal representation they can engage. I think where this came about was I believe the settlement amount, or not the settlement amount, but the award they got on the merits was just under $2 million. So the legal fees actually exceeded the award on the merits, and I think that's where they got into the sort of legal fee battle.
Right. Let's see. Did I have any other thoughts on this one? Oh, I just wanted to answer your question, Mike, that the underlying judgment was far less than what the Beastie Boys were asking for in attorney's fees. It was a $1.7 million award for the infringement itself. So, yeah, interesting case. And again, just one where adult supervision seems to have been absent from the decision-making process. I think we're going to shift gears away from entertainment-oriented stories and maybe hit one more substantive story before we go ahead and wrap up the show. And that one relates to crimes and justice and what's permissible under the law that you might find yourself running afoul of. Maybe one or two more stories. We'll see what we have time for. But Mike, you were interested, and it's always interesting to talk about 3D printed guns and the fact that it's possible to make them. And then once you have made them out of some sort of synthetic non-metal fabric, then it's possible to take them into places where they can't be detected. Tell us about this 3D printed poison dart gun that was created.
Well, there was an article earlier this week on TechCrunch. It was pointing to a guy's YouTube video where he as some kind of a protest to the State Department's coming out and saying that they were going to, I guess, clarify regulations around ITAR and export regulations around weapons, to say that it would be, the regulations would prohibit distributing blueprints for weapons on, I guess, online, or just generally distributing them to the world. And so this guy took issue with that. And so he made this, I think you can see it in the video stream, he 3D printed like a dart gun, and he made it so he could put like a scope on it and like a laser sight. and it's got rubber bands on the side of it. And it's just, to me, it struck me as kind of ridiculous, because it's, it's clearly not a gun. But what struck me that was interesting about it was that it didn't strike me as being all that controversial that the government would regulate distribution of plans for weapons. This is not treading all that new ground. Export regulations have always regulated the disclosure of information to people in other countries that are considered restricted by our country. And so, how you make a handgun may not be particularly useful to like a terrorist, although who's to say that the handgun won't be made in a fashion that could go through a metal detector? And then where do you draw the line? As the 3D printers become more effective, or you're using a more expensive 3D printer, if our goal as a government is to try to keep these weapons from moving from our country into countries that don't have them, restricting people from posting blueprints for how to make them seems like it wouldn't be that controversial. But I guess gun control is a hot button issue, and people feel really strongly about it. But I just thought it was an interesting story. And if you go to the video site, you can watch the guy shoot darts out of his gun and pop balloons. It's kind of, I thought it was kind of entertaining.
Yeah, it is. And it raises a whole mess of issues about what is going to be permissible in the 3D printing realm. I think we'll make blueprint our first MCLE passphrase for this episode of This Week in Law. If you are listening for continuing legal or other professional education credit, we put these phrases in so that you can demonstrate that you have watched or listened to the show. And if you need more information about that, go to wiki.twit.tv and find our This Week in Law page. And there you will find more information. Sarah, any thoughts on the 3D printed dart gun that is not an actual gun, but kind of, looks very much like one?
No, I thought it was kind of an amusing, not amusing, but interesting story. And I think 3D printing is going to raise a lot of new legal issues, not only copyright, but all kinds of, and it's interesting to see it now playing into, I didn't realize there was proposed legislation to make gun blueprints illegal, but I imagine we're going to see all kinds of proposed laws. I don't know what will actually happen, but what will come of it. But I think there's going to be there's a whole new world with 3D printing that we're just kind of just starting to see. So it'll be interesting to watch.
Yeah, right. Part of what to think about making the blueprints illegal, my understanding is they're not saying that you can't make a blueprint for a gun. They're saying don't send the blueprint of the gun to someone in another country.
To distribute, right.
Yeah, don't send it don't put it someplace where the terrorists are going to find it, which seems pretty reasonable. So it's more about where you disclose information as opposed to what information can be published.
Yeah, that seems difficult to regulate and craft laws around, though. How do you lock down the internet? It's everywhere. Yeah. Speaking of which, Michael, you also had the great idea that we should talk about states that have legalized medical marijuana, given that Cristelia is in Colorado and you're in Washington, right?
Right. Between the two of us, we probably have a better understanding than most about how the regulations are working. Not for medical marijuana, but for the retail. I think both Colorado and Washington are maybe the only states right now that have legal recreational marijuana.
Right.
Which is pretty interesting. It's, I don't know, I've been kind of fascinated with it. I thought it would have a bigger effect on the state than it did, and it just sort of happened, and everything is sort of continuing as usual. Not nearly as scary as we all thought it would be.
That's good. Yeah, I think this is one that has to play out over time to see, how the roads are impacted, people on the road driving under the influence, et cetera. But, I'm sure your police officers are very good at spotting people who are driving impaired from alcohol or other sources. So this is just one more in the mix for them. The tech angle I found for this has to do with an app that helps people out in other states where where marijuana is not just medically available, where it is just medically available, where it's not recreationally available. And this is a startup called Ease that makes it easy for you to do a video call with a doctor from your smartphone and get a prescription to go get your weed. Did you give any thought to making it quite so easy to put your hands on medical marijuana, Mike?
Yeah, California definitely seems to have an issue. From what I understand, I'm from California originally, and when I go back to visit, there are dispensaries everywhere, and so clearly it's not being used just for medical purposes. And this is a perfect example. I mean, people that have legitimate medical issues, that if they're in serious pain or they have a cancer, they're not setting up an appointment to see somebody on the internet for 15 minutes. I mean, so this is kind of an indication, I think, of probably an overall trend of the medical framework being expanded to as far as people will take it. So I feel like companies like this have kind of been trying to push the envelope on what's permitted, because they know that the federal government has been kind of lax on this, and that they see that the landscape is changing. And so in California, this strikes me as being kind of definitely the edge of the line in terms of pushing forward, making what is sort of a medical framework and trying to expand it to apply to anybody that wants to participate. And from what I understand, in states like California and even in Washington before recreational use was legalized, I think the cards basically are given out to pretty much anybody that asks the right person. So this seems like an incredibly risky business. But again, I guess it's one of those things where their choice is to either go ahead and try to start this business and see where it goes, or not try at all, and then in which case the outcome is zero gain. Although I don't know if there's criminal liability that could go along with trying to encourage people to use medical marijuana without actual need. I don't know. It seems like overall kind of a risky business to be in, especially in a state where it hasn't been decriminalized.
Right. Yeah, I definitely think this is one of those startup ideas that, again, maybe with a little bit more adult supervision might not have taken this leap, but we'll just have to see what happens to Ease. Cristelia, I'm curious whether you agree with Mike from your perspective in Colorado that legalizing recreational use hasn't changed much.
So I should preface to say I'm relatively new to Colorado. I've been here about a year, so I was in California before as well. And my impression was similar to Michael's, which was although California was technically a medical marijuana-only state, it wasn't difficult by any means to get medical, prescription for marijuana. So that it was a little bit more, in name than it was actually in practice. Now that I'm in an area where it's recreation is open, on a day-to-day level, there are dispensaries everywhere here. I'm in Boulder, which is a big college town, so maybe more so than other parts of the state. But I don't, as I understand it, the state and those cities where the dispensaries are most prevalent, like Boulder, I've not noticed an increase in crime. Unlike alcohol, I think a lot of the sort of day-to-day traffic violations that we see with alcohol, you don't see much with marijuana. People who get high don't want to drive anywhere, apparently. The biggest change I think Colorado has seen is really budgetary. My understanding is that in the first year of recreational legalization, they funded the free school lunch program for something like the next 70 years. So in terms of, revenue, all of the revenue from recreational marijuana has been earmarked for educational purposes in Colorado. So that it'll be nice to see if some of the educational issues that other states have had might be resolved with something like this. Maybe the biggest challenge for Colorado really has been lawsuits from neighboring states. I would say neighboring more conservative states, but Colorado is a bit of a purple state, so I don't even know if that's true. But there have been some concerns from some of our neighbors that recreational tourism, I think they're calling it, is filtering back over their borders. As far as I know, none of those lawsuits have been successful, but to the extent that having to defend these is a bit of a use of state time and taxpayer money, that's probably been the biggest downside.
Well, I don't know how we don't make 420 our second passphrase for this episode of This Week in Law. It's good to hear your impressions on how things are going in Washington and Colorado. I guess I would be concerned not only about how people are going to be on the roads, but how they're going to be on the ski slopes. But again, alcohol has been on ski slopes for quite some time as well, and is not exactly conducive to safe skiing. So I can't imagine that things would be that much worse. Hey, Sarah, I know you need to run, but I don't want to let you run until we get through our tip and resource of the week, which are both sort of in your wheelhouse squarely. Our resource of the week I've been wanting to highlight for a bit here is your Medium piece about doing what we're doing right here, getting on Skype or on TV or otherwise getting up in public and talking for a while. I was really interested in your piece, and I think you had some great insights.
Oh, thank you.
Do you want to share the high points with folks?
Sure. So I wrote a little bit about, I've been kind of thinking about this in my head for a while and kind of finally got it published. But just thinking, so I guess to preface, like doing the show is completely out of my comfort zone. But I've really enjoyed it and I've learned a lot. And so I decided to write something about it. And so I kind of had three big takeaways that I wrote about. One is the first one was just that reading more isn't the answer. I think when I first started doing the show, I would spend so much time just thinking, well, I got to read more, I got to read everything I can get my hands on about the show topics. And pretty quickly realized that A, that wasn't possible, and B, it was almost counterproductive after a while because you'd start to confuse yourself, or I just felt like, you get the baseline facts and then you have to kind of step away and maybe just do some thinking about it. And that actually is sometimes more productive than reading more. And then also wrote about how kind of connecting dots is something that is really useful because most people haven't had time to think about the show topics, and you don't have to come up with something original. It's just a matter of kind of connecting different concepts with other things, and how that's really a valuable exercise. I know I learned from you and from our guests when I'm on the show with doing that, and then also that you don't have to know everything to have something to say. So it was kind of a fun little piece. Spilled my guts a little bit there.
I think they're useful insights for folks, and that's why I wanted to highlight it as a resource. Everybody has to do public speaking at one time or another, and to do so in a conversational format like this is really fun and really flexible. And one other thing I would just add to the great points you've brought up here is, the thing that annoys me the most about talking heads that I see on TV is people trying to bluster their way through topics that they really don't know that much about. And right. I think the best approach there is just, to fess up and say, that's not really precisely in my wheelhouse. I have some thoughts on it, and here they are, but I'm just going to tell you, that's not really my bag. Of course, you don't really get people copying to that too much on TV, and it's refreshing when you do. So I hope that people will be honest in their public speaking as well. Now, the other thing you've been working on all week has to do with open business models, and this becomes our tip of the week, is think about adopting an open business model. And this is something that Creative Commons has been working on and has a Kickstarter going right now along the lines of. So can you tell us about that?
Sure. Yeah, so we launched on Wednesday a Kickstarter, and our goal is to write a book about business models that involve Creative Commons licensing, and it'll be in every domain out there. We're not going to focus on open source software because we kind of feel like that story has already been written. It'll be more about content. And so, yeah, the project is off to a good start. This is our first time doing crowdfunding on Kickstarter, and quickly realizing that it's a lot of work. It's not just that you launch it and it goes. You got to be constantly, trying to promote it, and so it's a fun project for me, and we're anxious to see where it goes. But
so you guys are raising funding to write a book about open business models and how they might be useful to consider. Is it going to be a crowdsourced book? Who is the author of the book? Tell us more about that.
Oh, sure. So I will be one of the authors, and then my coworker, Paul Stacy, will be the other. And the idea is we will profile 24 businesses, creators, nonprofits, probably a mix of all of those over the course of a year that are using Creative Commons licensing, and figure out the idea is to ultimately produce something that other people can use for what they're doing. And we'll have an interactive tool in addition to the book that helps people kind of evaluate their own business models and reuse and remix what other people are doing. But we'll be the authors, and hopefully our Kickstarter backers will be involved too. We have one of our reward levels is for people to be a co-creator. So we'll send them early edits of the chapters as we're working on them, and it'll be a very collaborative process, and it'll happen over the course of a year. So
wonderful. Good luck with that. And we're going to go ahead and get out of here so that you can get back to working on that and your other projects for Creative Commons, and our other guests can get on with their lives, and the audience can get on with their lives as well. We've been thrilled that you've been able to join us today for This Week in Law. We record the show every Friday at 11 o'clock Pacific time, 1800 UTC, and that's when you can catch us live if you go to twit.tv and play along with us, warts and all, as we do the show. The show is also available after the fact at twit.tv/TWiL. Our whole archive of shows is there, and it's also available on YouTube and various other channels, in iTunes, of course. If you go to the twit.tv/TWiL page, there is a whole compendium of ways that you can watch the show. So find one there that makes it easy for you on your own time, or join us live if you can. It's always fun. We love interacting with our folks in IRC and getting their feedback during the show while we record. Thank you so much for joining us, everyone who has done that in IRC and helped us out today. They're a big part of the show. Also, you can help us out by getting in touch with us between the shows. Sarah and I are both on Twitter. She is S. Hinch Pearson, and I am D. Howell there. That's a great way to get our attention as to stories that you think might be interesting for us to cover on the show, or guests who you think we should invite or tap their brains. We always love hearing about your ideas for that. You can email us too. Sarah is sarahp@twit.tv. I'm Denise at twit.tv. Or check us out on Facebook or on Google+, if you'd like to have a more sort of lengthy public discussion. Those are good places to do that. And we've just really, really enjoyed being here with you this week. We will be back next week with a whole new panel of guests. But before we get out of here today, I have to say a huge thank you for our guests who have joined us today. Cristelia Garcia from University of Colorado Boulder School of Law. Anything going on with you, Cristelia? Any speaking coming up? Any cool things going on at the law school that you want to share with us before we go ahead and say goodbye?
The University of Colorado's Silicon Flatiron Center for Law and Technology has a lot of events going on throughout the year. The next real copyright-related one will be in March, but I encourage you, if you're interested in law and tech things, whether you're in Colorado or elsewhere, because a lot of the events are live-streamed, to check out the Silicon Flatiron Center for Law and Tech and see some of the events. We've got some really interesting stuff going on.
Thank you. We will definitely check that out. And thank you so much for joining us today on the show. And Mike Schneider, it's been a real pleasure meeting you. How about in your neck of the woods? Anything going on that you want to let us know about before we leave?
Well, I'll be speaking in Denver at 360 iDev. I do a lot of work with iPhone and mobile-related companies, and so I'll be there in August. And then we have the podcast that we do once a week called the Law of Startups, and it's really just us talking to local startups in the Seattle community and talking about a little bit of legal issues and a bit about entrepreneurship and starting up companies. So. Check
Great. Always the need for that, and for adult supervision, as we've pointed out several times on this show. So it really can't thank you two enough for joining us. Sarah, great chatting with you too, and thank you to all of our audience members who have joined us today. We will see you next week on This Week in Law. Thank you.